I need to tell you something uncomfortable but absolutely critical. Right now, if something happened to you tomorrow, your family would face a legal nightmare that could last years and cost tens of thousands of dollars. And the worst part? You could prevent all of it with just 5 simple documents. Most people think estate planning is only for the wealthy. That's completely wrong. Whether you have $1 million or just a modest savings account, without these documents, your loved ones will suffer. They'll fight in court. They'll argue with hospitals. They'll watch your wishes get ignored. But here's the good news. You can fix this problem in a single afternoon. These 5 documents aren't complicated. They don't require expensive lawyers. And they'll give you peace of mind knowing your family is protected no matter what happens. Let's start with the most important document that most people have never even heard of. It's called a living will, and it could mean the difference between your family honoring your wishes or watching them get trampled in a hospital room. A living will tells doctors exactly what medical treatments you want if you can't speak for yourself. Think about it. If you're unconscious after an accident, who decides whether you stay on life support? Without this document, it won't be the person you trust most. It'll be whoever has legal authority, and that might not align with what you actually want. This document covers critical decisions like resuscitation, mechanical ventilation, feeding tubes, and pain management. You specify exactly what interventions you want and which ones you refuse. It removes all the guesswork and prevents your family from having to make impossible choices while they're grieving. Here's what makes this even more important. Without a living will, hospitals follow default protocols. They'll keep you alive by any means necessary, even if that's not what you would have wanted. Your family will watch you suffer through treatments you never agreed to, and they'll be powerless to stop it. The document needs to be specific. Don't just write vague statements like "I want comfort care." Detail exactly what that means. Do you want antibiotics? Dialysis? Surgery? The more specific you are, the better protected your wishes become. Now let's talk about document number 2, which works hand in hand with your living will. It's called a healthcare power of attorney, and it might be even more crucial than the first one. This document names someone to make medical decisions for you when you can't make them yourself. Your living will covers your general wishes, but medicine isn't black and white. Unexpected situations arise. New treatments become available. Your healthcare agent handles all those gray areas. Choose this person carefully. They need to be someone who knows you deeply, understands your values, and has the strength to advocate for you even when it's difficult. This isn't about picking your oldest child or your spouse just because of their relationship to you. It's about choosing the person who will actually fight for what you want. Your healthcare agent will talk to doctors, review treatment options, access your medical records, and make decisions about surgeries, medications, and care facilities. They'll be your voice when you have none. Make sure they know what you want before a crisis happens. Have detailed conversations with this person. Tell them your fears, your priorities, your deal breakers. Would you want to live in a vegetative state? At what point would you choose comfort over treatment? What does quality of life mean to you? These aren't easy conversations, but they're absolutely necessary. Document number 3 is where we shift from healthcare to finances. It's called a financial power of attorney, and without it, your family could lose everything while you're still alive. Here's a scenario that happens every single day. Someone has a stroke. They survive but can't manage their affairs. Bills pile up. The mortgage goes unpaid. Investments need managing. But nobody has legal authority to access the accounts. The family has to go to court, spend thousands on lawyers, and wait months for a judge to grant conservatorship. A financial power of attorney prevents all of that. You designate someone to handle your money, pay your bills, manage your investments, and make financial decisions if you become incapacitated. This person can act immediately without court involvement. You can make this document as broad or as limited as you want. Some people give their agent complete control over all financial matters. Others restrict it to specific accounts or types of transactions. You can even require two people to act together for major decisions. The key is choosing someone trustworthy and financially responsible. This person will have access to your bank accounts, investment portfolios, and property. They could theoretically drain everything. That's why this decision requires serious thought and often benefits from having checks and balances built in. Consider naming a backup agent too. If your first choice becomes unable or unwilling to serve, you need a second option ready. Don't leave this to chance or force your family into court battles over who should manage your affairs. Now we get to document number 4, the one everyone has heard of but most people still don't have. It's your last will and testament, and yes, you absolutely need one regardless of your age or wealth. A will does something simple but crucial. It tells the world who gets your stuff when you die. Without it, state law decides. And I promise you, state law doesn't know what you would have wanted. Think you don't have enough assets to worry about? Wrong. You have personal possessions with sentimental value. You might have a car, a bank account, retirement funds, or life insurance. Someone needs to inherit these things, and you should decide who that is. Your will also names an executor, the person who manages your estate after you die. They'll gather your assets, pay your debts, file your taxes, and distribute everything according to your wishes. Choose someone organized, trustworthy, and capable of handling conflict, because estate settlement can get messy. If you have minor children, your will is where you name their guardian. This might be the most important decision you ever make. Who would raise your kids if you couldn't? Who shares your values and would love them like their own? Put it in writing, or a judge will decide for you. Your will should be reviewed and updated regularly. Marriage, divorce, births, deaths, major purchases, these all require updates. An outdated will can cause just as many problems as no will at all. Finally, we come to document number 5, which many people overlook but could save your family enormous hassle and expense. It's called a letter of instruction, and it's your chance to leave detailed guidance about everything your legal documents don't cover. This isn't a legal document, so it doesn't need lawyers or witnesses. But it's incredibly valuable. You list all your accounts, insurance policies, debts, and assets. You include account numbers, passwords, and contact information. You explain where important documents are stored. Think about what your family would need to know if you died tomorrow. Where's your life insurance policy? What's the password to your computer? Do you have a safe deposit box? What are your online account credentials? Who should be notified? What are your funeral wishes? This letter saves your family from spending months searching for information while dealing with grief. They won't have to guess which bank you used or whether you had life insurance. Everything they need is in one place. Include your funeral preferences too. Do you want burial or cremation? What kind of service? What music? These details matter to grieving families who want to honor your wishes but don't know what they were. You can also use this letter to leave personal messages. Explain why you made certain decisions. Share memories. Express love. Say things you might not get to say otherwise. This transforms a practical document into something meaningful. Update this letter annually or whenever major changes occur. Keep it somewhere safe but accessible. Tell your executor and family where to find it. Consider keeping both physical and digital copies in case one becomes unavailable. Now let's talk about what happens if you don't have these documents. The consequences are severe and far more common than you might think. Without a living will, doctors make medical decisions based on hospital policy and legal liability, not your wishes. Your family watches helplessly as you receive treatments you never wanted or get denied care you would have chosen. Without healthcare power of attorney, family members fight over medical decisions. Siblings disagree. Spouses clash with parents. Everyone thinks they know what you'd want, but nobody has legal authority to act. Hospitals won't listen to any of them. Without financial power of attorney, your bills go unpaid while your family begs courts for access to your accounts. Your credit gets destroyed. Your house goes into foreclosure. Your business collapses. All because nobody could legally touch your money. Without a will, state law distributes your assets in ways you'd hate. Your estranged sibling gets the same share as your devoted spouse. Your best friend who's been like family gets nothing. Your favorite charity receives zero. The state doesn't care about your relationships or wishes. Without a letter of instruction, your family spends months tracking down accounts, searching for documents, and trying to piece together your financial life. They miss deadlines. They lose money. They make mistakes that could have been easily avoided. So what do you do next? Start with the basics. You can find free or low-cost templates for all these documents online. Many states provide official forms on their government websites. You don't need to spend thousands on lawyers for simple situations. Schedule a weekend afternoon to tackle this project. Gather information about your accounts, insurance, and assets. Think carefully about who you trust to make decisions for you. Have honest conversations with the people you want to name in these documents. For straightforward situations, online legal services can help you create valid documents for a few $100s. They'll guide you through the process and ensure your documents meet your state's requirements. It's not free, but it's infinitely cheaper than what your family will pay without them. If your situation is complex, involving significant assets, blended families, or special needs dependents, invest in a qualified estate planning attorney. Yes, it costs more upfront. But it saves exponentially more in taxes, legal fees, and family conflict down the road. Don't wait for the perfect time. There isn't one. Don't wait until you're older. Accidents and illnesses don't check your age. Don't wait until you have more money. These documents matter regardless of your net worth. Remember, this isn't about you. You'll be gone or incapacitated. These documents protect the people you love from unnecessary suffering, expense, and conflict during the worst time of their lives. That's worth an afternoon of uncomfortable planning. One final thought. Having these documents isn't morbid or pessimistic. It's one of the most loving things you can do for your family. It's taking responsibility. It's removing burden. It's giving them the gift of knowing exactly what you want and having the legal authority to make it happen. Your family will thank you for this preparation. They might not say it now, but when the time comes, these 5 documents will be the most valuable thing you leave them besides your love and memories. Don't make them wish you had done this. Do it now while you still can.